Right, everyone. Welcome. It's wonderful to see all of you. I'm excited. Thanks for spending part of the morning with us. I know that your time is super precious. So I appreciate your willingness to spend some of it with us today. This is a topic that's near and dear to my heart. And I'm hopeful that this will encourage you and those who you work with at your various organizations to, even if you are working with these campus survivors, to take on more, to expand, or if you aren't working with them, to consider trying one case or kind of sticking your toe in the water of trying to take one of these campus cases. So I will mention before we get started that I did a session one, like a part one of this about a month ago. And it went into a lot of work that goes into these cases before you ever get to a conduct process. And if you haven't seen that, we recorded it. I would recommend that you go ahead and take a look. At the end of today too, we're going to be handing out a checklist that covers both of those sessions. So the first session and today's session as kind of a 2-page handy guide that you can keep with you at your desk or refer to when you're working with campus survivors. So we're finishing off the topic today about working with campus survivors. So just to give a little bit of introduction, my name is Lindy Aldrich. Some names on here I recognize. I used to be at the Victim Rights Law Center in Boston. I was there for 13 years. It's where I got to know Hema and many others of you. Hope you all are doing well. I went out on my own in 2020, just in time for the pandemic, and decided that I wanted to keep a focus on not only the Title IX work that I do, or I did at the VRLC, but I also wanted to be able to really dip back into advocacy. Of the 13 years that I worked at the VRLC, I think that was one of the biggest learnings I had was the power of advocacy, the power that when survivors met up with someone who could help them navigate systems, that it really helped them to be better informed and to make choices that were the best for them. So a lot of the work I've been doing has been with advocates in a wide variety of settings. So when Jane Doe came and asked if I would be willing to kind of explore the most recent campus law that intersects with advocates, I was thrilled. I had been a part of that specific legislation for 6 years prior to its passage. So now this is almost like getting to see how we implement that law. So it has been really a joy to be able to work with you all and to kind of dig deeper into those, kind of what services and resources are available. So just to give everyone a little bit of background, last time we talked about the needs assessment where I spoke with many of you. But this is where we jumped into the implementation plan. And what we really came away from the needs assessment was that we needed to build capacity, right? That folks expressed some concern about feeling that maybe staff didn't have as much information or felt hesitant to take on a campus client and to work with a survivor who was involved in a conduct process or who had made a report. So we wanted to do some specific trainings. We wanted to come up with some tip sheets. And we're going to be doing some share and learn calls because so many of you had knowledge and so much expertise that we thought, well, it isn't just about me. We can all learn from each other. So be on the lookout for that. I am also working on a sample MOU that I know many of you already have them. but I wanted to offer up some potential thoughts and considerations that you could, when you're working with an institution, maybe you want to expand the relationship, and to give you some of that language, and to think through some other ways to create programs that would expand the relationship with the campus, but also obviously provide more trainings and a revenue source for your particular organization. So it really is a twofold idea here. So be on the lookout for that as well. So today, we're going to focus on 4 kind of big topics. One is going to be a bit of review. We're going to talk about receiving a report, how the campus, gets that information and what happens. And you'll notice that the next one says filing a complaint, which feels like the exact same thing, but it's not. We're going to talk about the very specific legal things that have to happen in order to file a complaint. Then we're going to talk about what are the different types of conduct processes there are. Obviously all the campuses you're working with are very specific and unique. However, there's some big kind of buckets, like genres that these processes fit into. So we're going to talk through kind of like what the different ones are, and hopefully the idea is that you'll be able to really use this to explain it to a survivor. And then lastly, what are some of the considerations that an advocate should use? So kind of like putting on the important pieces of your work, and kind of how do you protect yourself as well as the survivor when you're working within these processes. So we have a tall order today, but we're gonna get through it. I would love it if you have questions, please feel free to put them in the chat. We're a small group, so if anybody just wants to unmute or raise their hand, please feel free to do that. I don't mind being interrupted at all. So please just let me know if you have a question or if there's a topic. I also have some questions that I'm interested to hear from you about. So just know that there are lots of opportunities. All right, so let's jump into receiving a report. Again, these first few slides are review from last time. It's where we left off. And I just want to make sure that we're seamlessly moving into the next piece. So just for clarity's sake, I want to bring up a legal term that you may hear campuses use. So the words actual notice is when an institution, right, a campus, learns of prohibited conduct from any employee that meets the Title IX requirements. So, we went through a bunch of what those requirements were at the last training, but just to refresh, one was, are the parties affiliated with the institution? Are they a student? Are they an employee of that campus? Whether the conduct was during a program or activity. So that's going to be things like, was it on campus? Was it at an away athletic event or a field trip, or, some kind of school sponsored research focused project or something like that? It has to be affiliated with the school. And then lastly, the conduct itself has to meet the requirement of Title IX. So I don't know if you remember this wheel from last time. So this is all of the kind of the breakout of when we talk about sexual harassment. Title IX uses a very specific term of sexual harassment, but it actually breaks out into a lot of different, obviously what we would be very familiar with as other forms of violence and discrimination. The most recent regulations that came out in 2020, they also borrowed some definitions from the Clery Act. And instead of last time, it wasn't very clear whether dating and domestic violence and stalking were a part of Title IX. Well, now that is completely clear. So this is the range of behaviors that would be considered prohibited. I do want to point you to the gender-based harassment segment. Be clear that that encompasses discrimination, which can also be jokes or actions taken to discriminate against folks based on their gender, which does expand to LGBT folks and their exclusion from, being able to join athletic teams, being able to join clubs. Just know that gender-based harassment is not, it doesn't necessarily have to be tied to violence. It can be just the exclusion from a group. So I wanted to make, that was a point that last time I wasn't sure if that was clear. So I want to make sure that it is here. So if somebody is interested in reporting and they get to the stage where they want to speak to the Title IX coordinator, Title IX requires that the Title IX coordinator has to provide the following information. They have to explain the reporting process, and that includes what what we would call a grievance process, meaning how they would do the conduct, how would they do the investigation. They have to offer supportive measures, and we talked a lot about those before, and we'll talk about them again. You do not have to file a complaint in order to get supportive measures. So those can include things like changing classes, changing residence halls, changing where you park, or getting some kind of accommodation. So there's lots of different things that can be done at the supportive measure within supportive measures. And lastly, they have to provide a copy of all relevant policies. So you can never say they have to provide you some either written document, or they have to email you the links to the relevant policies. Now, it's really important to know, again, just as review, that the reporting party does not have to report. Just by attending a meeting with the Title IX coordinator, they can still decline, right? They can say, nope, I appreciate this information, but I'm not interested. But if they do wish to go forward, they're going to have to file a written complaint, and that can be either an email, or some schools have like a written form. And we're going to talk a little bit more about what that is. So I just wanted to throw in here about the types of supportive measures that are included. Now, one of the things we talked about at the last session, and I think this is an excellent resource that advocates provide that frankly campuses and K through 12 don't either, is safety planning. I consider them to be very different pieces. So when we're talking about supportive measures, it's a Title IX function that basically says, we are going to help you to continue your education. And it does not necessarily mean that there's fear, or that it's essentially saying, we want you to continue to go to class. We want you to continue to be a part of extracurricular things like sports and band and student government, things like that. So we're going to put the following pieces in place to ensure that you're able to continue on with that. And you can also imagine that there are folks that, say in a sexual harassment setting, that are not afraid, right? But they do wish to get out of that class, or they do want to get out of that residence hall, or they want just basically consequences for the behavior, but they're not afraid. And for those who are afraid, and with valid and legitimate reasons, I think this is where advocates obviously can provide a lot of expertise, and they can show a lot of leadership in the campus setting to say, these are the steps we want to take for safety planning. So I throw this up here in terms of supportive measures, but I also wanted to make sure that I'm clear that, I consider these to be two separate things. And I'll be honest, I don't think that many campus administrators are very good at safety planning. It's not something that they've been trained in normally. So this is something that I think, any advocate, community or campus-based, is really good at and can help navigate these types of separate needs well. So I wanted to throw that up there as a second piece. We also talked about this extensively in the first session of this webinar. So, if you want to have a refresher on anything about how they work together, I welcome you to go back and take a listen to that. So everybody good with that kind of quick review, because now we're going to start going into new material. Anybody's got questions, please feel free. Happy to chat any of this out. Seems like everyone's in good shape. All right. So let's move on to the next section about filing a complaint. For advocates that are new to this process, I want to be clear that just telling the Title IX coordinator about an incident does not equal filing a complaint. And so we really need to talk about what that process is to file a complaint. I know in my past, I've worked with lots of survivors who thought, by just telling someone that equaled some kind of complaint. I'll be honest, the current regulations are very specific about how a complaint needs to be filed. And there are very few people on campus that can actually take a filed complaint. So it's important, I think, to kind of make sure that you're familiar with what this is, because I'm concerned that sometimes survivors, especially those who say are working with a mental health counselor, or they might be working with another confidential resource on campus, and they're not quite understanding that this is not the same as filing a complaint. So again, information is power. Helping them to, really get an understanding of what it's going to entail at that beginning stage is huge. All right. So formal complaints, they have to be either in writing via an email or some kind of written letter, and it must be signed by the complainant, by the reporting party. Another thing is that if you file a formal complaint, schools must investigate. It is not a choice. They must investigate if somebody has filed this written form and made, an allegation that falls within Title IX, right? And even if law enforcement is investigating, and that could be law enforcement at the campus, or it could be local law enforcement, the school still needs to have their own investigation. So I honestly, I say this to you too, because some of you may be working with K through 12. And that's what I'm hearing a lot in K through 12 settings is, well, this is the police's job. Nope, it is also the school's job. And Title IX covers both K through 12 and campus. So there should never be this kind of pushing off to the police. They must investigate. One of the things I will also say is sexual harassment is not a crime, right? So if you are being harassed by a professor or by another student or an employee of some kind, police are not really an option. So it is still a violation of community standards at that particular campus. So it's important that, we don't kind of put those two ideas together. And I know that I'm preaching to the choir with you all, but just know that it's rooted in law, that they cannot say, well, let's wait on law enforcement. They can wait a small amount of time for law enforcement to investigate, meaning, a couple of weeks maybe, but it cannot be, well, we're going to wait for the entire process to come to a conclusion, right? So it's, just know that they have to determine whether their policies have been violated, not just whether criminal law has been violated. And there's no timing requirement. It's important to realize too, some schools, I get really anxious when I see a policy that says, you have 2 months to, put in a report. No, There's no timing requirement. I've seen, folks file formal complaints 3, 4, 5 years after an incident. So just know that there's no requirement. And frankly, if you found a timing requirement in a policy, I would love for you to, maybe reach out to the VRLC or local local attorneys in your area, because if that's prohibiting people from coming forward, I think there's good cause to say that that's a violation of Title IX. So just to give you a couple of areas to kind of keep in mind when it comes to filing. Now, I want to bring this up not to cause any alarm, but I want to make sure that advocates and the survivors they're working with are not blindsided when something that, it is not likely to happen, but I want you to be aware of it. So in the event that a campus has information about a respondent, right, or the party that has been accused, that they reasonably believe is a school safety issue or a community safety issue, they can proceed with a complaint even without the survivor. So I think just the thought of this can be chilling, right? It can make survivors say, oh, if I'm not going to control this process, then I don't want to go forward. And I completely understand that. I think it's important that survivors know that this is a possibility. However, I do want to be clear that it's not likely. I actually did some polling with some local attorneys that I've been working with who've been working with campus survivors, and they said it's really infrequent that schools.
I really don't understand what's happening with my computer.
Yeah, and then I have Emma, then I have Taylor.
Oh, thank you. So just know I would bring it up and say that it's rare. But one of the things I found in most instances is that the school generally is aware of other victims that perhaps the survivor you're working with is not aware of. I know I worked on a case in another state where they had one victim come forward, and it was a digital penetration case. And essentially, they started to do an investigation because they had another victim come in, and the two victims that had complained did not know each other. As it turned out, there were 8 victims, and the school opted to go forward with their own complaint. Everything was digital penetration. Oddly, it happened at bus stops. So it was just one of those cases that when they started to put the patterns together, they found that, this was a person who obviously had been behaving in this way over the course of years. So, I think sometimes it's warranted because even, I think not all, but some survivors, when they find out that there is a string of survivors, some, especially in a case where it's, repeat, gropings or discriminatory comments, or other dating violence, some survivors will say, yes, I'm willing to kind of come together as a group and file these joint complaints. So again, that's not for every survivor, but some schools, upon realizing that they have somebody who's repeatedly or escalating in their violent behaviors, do feel that they need to go forward as a campus safety issue. So I just wanted to let you know, they also have to document in writing why they are proceeding. That's a requirement under Title IX. So I throw that out there to you, that, it's unlikely. If they did do it, you could ask, specifically, what information could they provide to your survivor to help them understand. And just know that this does not require your survivor to cooperate in any way. But you are going to want to be clear about safety planning. Obviously, I'm hopeful that the school would take steps to alert folks if if a complaint were going forward so that they could get off campus or take certain measures to feel safe. So just want to throw that out there as a potential caveat. Anybody have questions on that? Or have any of you ever experienced a case where this has happened to a survivor? I would be, and it's, honestly, if this happened like a while ago, I would not be shocked. But in recent years with the regulation changes, it is more specific about how you have to file a complaint. So I think we're seeing less and less of this being an option, just because, I don't think, frankly, I just don't know that many survivors are reporting a lot of this repeat behavior. Okay, well, it seems like folks haven't seen it, which I think is a good sign. So if you were to, kind of run into an issue, you can always reach out to the VRLC, or I'm happy to chat you through it as well. Okay, so the last kind of legalese that I will show you is this idea of notice. And again, I just want you to be aware of, not only what your survivor should expect to have notice of, but also what the accused student is also going to be receiving. So in order, you have to, in a formal complaint, there is a requirement that these certain levels of notice be met. So what that's going to be is the person who's been accused, right, the respondent, they're going to receive in writing this formal complaint. So it's going to include all the information about the process, the different policies. There's going to be the name of the party, or if there are multiple victims, it's going to have all of the names, date, time, location, right? So it's going to be very specific, and it's going to tell like what specific violation has been alleged. This notice requirement extends, right? It'll also extend that, all parties have the right to review relevant evidence. So it's not going to be just at this written complaint stage. It's going to extend into evidence that's gathered and giving, sufficient time to respond to that evidence. So just know that notice is actually something that's at play throughout the process. I also wanted to note, there's ongoing times when there has to be notice that aren't on here. So for instance, if there's going to be a delay, they have to do that in writing. They have to notify both parties, say, one of the hearing panel members had an unexpected health emergency, so we're postponing the hearing for a week. That has to be given to you in writing. If there are additional allegations, and just so you know, my significant other is not going to be late if you heard him screaming at me. If there are additional allegations that occur, this happens a lot in dating and domestic violence cases, where as the investigation continues, other incidences come up, and you have to, basically give each party the opportunity to amend the complaint. And I will tell you, in cases with dating and domestic violence, it also means the respondent can file what we would call a cross complaint. So they'll say, the survivor that you're working with kicked me, and then they'll use that as a cross complaint against the survivor you're working with. So again, these are, they have to, but they cannot just add it onto the list. There has to, that same notice requirement works in both directions. So just to be aware of that. And then again, you have to have, the reason for notice is that you have sufficient time, right, to prepare, to review evidence, to prepare for a hearing, right? So they can't just give it to you 30 minutes before you walk in. They can't just ask you to review, 50 pages of text messages, an hour before you head into a hearing, right? So they have to give you sufficient time. And I encourage, those who may be working with folks, that you push back if they are trying to make you do it very quickly. and this is something just to even alert, the survivor you're working with, is like, you can push back and say, this is too short. I have an exam, I have, work. I can't review this in an hour, or I can't even review this over the weekend. I need additional time next week. These are things that you can push back on. So before I jump into the types of conduct process, I want to make sure everyone clear on, kind of how to file a formal complaint. Everybody good on the notice piece? Because the next step is really how to help a survivor prepare for this next phase of the conduct process. I'd love it if I would just be super interested, is when you have worked with campus survivors before, can you give me a sense of where they are at in the process? So for instance, and I'd love just if you wouldn't mind putting in the chat, are they not reporting? Do they need information, or are they, say, undecided? Or are they already involved in a process? And it's okay if you haven't had any of this. I just would be curious, for those of you who have worked with folks, I'm not clear as to when in the process you end up seeing them, like, more often. If you end up seeing them at the very beginning, or if they're already halfway through a process. Anybody have any thoughts? I'd love to hear from you. Just because I'm kind of curious, because that, obviously where they are in the process can change the way you have to give, counsel, when you have to give them advice on kind of what next steps they should take. Not so much that I think you have to know the law, but one of your pieces of advice would be, let's see if we can find you an attorney. Or maybe it's, you need to see if we can't get you an appointment with a counselor because it's causing you such trauma, it's re-traumatizing you. All right, thank you so much. So somebody's saying that many survivors are not reporting, which I hear that. Others who are in the formal process often reach out when they have a deadline. Exact. Oh, okay. So in order to respond to an investigation report or to attend the actual proceeding. Oh, that's really interesting. I'd love to hear from you all, just if you are seeing similar. I think my experience with campus survivors, it's interesting. Obviously when they would get to the VRLC, many of them were looking to proceed to go into this reporting function. But there were many who just needed information. They were still undecided, and they needed to figure out what were some of the risks, what were, they had certain goals that they were looking to achieve. Excuse me. But they were also really trying to figure out, what information was going to be handed out. No, sorry. What kind of privacy they could expect. And that oftentimes what safety they could expect. That would really help make the decisions for them once we got into a better understanding of the process. For those who are already in the middle of it, and I hear you about, the hearing is happening on Friday and they get in touch with you on Wednesday. Or they need to take a look at a report and they're lost, or frankly re-traumatized by it. So they don't feel comfortable. It's too hard to go through that report with a critical eye. So just kind of think about, like what you do as an advocate, and how, what comfort level you would have in engaging in kind of those two separate times, right? So one is at the beginning where you can really think through some pieces, but what happens if they come to you and they're already very much engaged in a process, and thinking through, kind of, would you make a referral at that point? Would you be really clear about what roles you felt comfortable having? And we're going to talk a little bit more about that. All right, so let's jump into the types of conduct. There are really 4 specific, kind of bucket areas of the conduct process, and we're going to talk about each one of them. I do want to mention that every school has its own unique policy and process. And so it's important to realize that you're not going to find exactly what I'm talking about here at every school. You're going to find versions, I think, of these, but I wanted you to at least be aware of the different types, and to see in some ways the progression that conduct has made over the years. So we're going to start with the single investigator. And actually, you know what? I want to make one quick thing before we jump into the types. I'm sure many of you are aware that the most recent regulations in 2020 established that there is a requirement under Title IX for campuses only to include cross-examination of the parties in a live hearing. We're going to continue to talk about this issue as we go through each of these pieces. It is real. And I think many of you who work with campus survivors know what a chilling impact it has on reporting. We're going to talk through like each of these pieces. And, I just wanted to be clear that I'll be honest, we expect new Title IX regulations to come out in May. There's some pressure right now on the Biden administration to hurry up and get some new regulations out there. They have already gone through a lengthy notice and comment period. And, now it's time to release something new. And I think the one point where everyone's kind of holding their breath is whether or not this cross-examination piece is going to become optional. I think it would be naive to think that cross-examination would go away altogether. I think at this point we have it. I think what's going to happen is that schools are going to be allowed to choose one or the other, or some version of cross-examination is going to be included. So just know that as we go through, I'll kind of highlight where cross-examination is going to kind of factor into each of these processes. All right. So the single investigator, as you can probably guess, this is a model where one person does all of the investigation and one person determines the responsibility. You can also imagine that the biggest problem with the single investigator is the single investigator, especially when we're talking about gender-based violence. When everything comes down, in any case, when everything comes down to one person having to have the appropriate training, the one person not being biased or have a conflict of interest, the one person, who lacks the ability for checks and balances, when you're, the judge, jury, and executioner, it leaves a lot of room for error. And I'll be honest, the new regs, you will almost never see a single investigator in a campus conduct case anymore. Back in the early 2005 up until or even 2000s, this was the only model in many schools. And I'll be honest, in K through 12, it's still the model. It is the only model. K through 12 does not require that there's a cross. So it essentially allows a single investigator model to continue. I bring it up because you might see it in a campus case in an informal resolution type of experience. So we're going to talk a little bit more about it. But I want to kind of show you the progression that conduct cases have gone through from where we started at and how, kind of how things have moved forward. So keeping that in mind, the next model is the hearing panel model. Now, this normally consists of 3 or more members, right? And generally there's a panel chair. And that person, the chair, is expected to answer questions and really direct the flow of the hearing. Generally, the panel chair does not vote. they don't have a vote in determining whether or not there is responsibility. They have to determine relevance of the evidence, and they also have to say no to certain questions in the cross-examination period. So they have that chair has a very important role, but it often gives them additional access to the parties and to maybe their attorneys or their advisors. So that's why we don't typically have the chair be a vote, because we want to keep the panel as, focused and without allowing other pressures onto the panel. So we want to kind of keep them secure and protected. So typically these panels are trained once a year, at least once a year, in how to handle these types of cases. But it's important to note that all evidence is gathered at this hearing. So you can imagine that you have, say, multiple witnesses. You have, both parties and their cross-exam. You have witnesses. You may have surveillance footage, text messages. There's a variety of things that may need, law enforcement could have shown up. They may want to interview if they went and had a saying. I mean, who knows? There's a million things that could go into a hearing. So when you're gathering all of the information in one day, that puts a lot of pressure on the panel, right? And certainly, people have busy lives and they have, I don't know that a panel has 5, 6, 7, 8 hours, to sit and gather all of this information. So, I think panels, while they allow, right, for diversity of experience, people come with different lenses so that they're looking for different checks and balances on each other. So there's that nice kind of function there where you have that opportunity to hear from different voices. Yet at the same time, it puts a lot of pressure on a very short amount of time to do something thorough. So I will say this panel, though, they gather all the information and then they come to a finding. They deliberate and they say the person is responsible or not responsible. So as you can imagine, this next section is what we call the hybrid. And that's where we have the investigator and the panel working together. And it's essentially taking the best of both models and coming up with something that's more fair and something that's more streamlined. So this is generally how these work. The investigator will spend several weeks speaking with the parties, speaking with witnesses, gathering all of the evidence, the text messages and the video, and speaking with the RA and gathering all this information, and they issue a report. One of the kind of unique areas is that some campuses will ask the investigator to give their recommendation on a finding. They'll say, you say based on your investigation whether you would recommend that this person is found responsible. A lot of campuses, though, don't ask an investigator to do that. They just ask for all of the facts to be placed into a report. That report is then given to both of the parties, who are able to make edits, who are able to respond and say that's not true, or you don't have where are all of my text messages I gave you, right? Once that report is finalized, it is then given to the hearing panel, who is given generally at least 24 hours to read the report and prepare for the hearing. Now, the hearing panel is acting as that checks and balances functionality. Similarly, when they're on their own, now they're doing a checks and balances for the investigator as well, right? So they are asking the investigator questions. Why didn't you find out about this? I think there's a gap here. Why were you not able to speak with the roommate? Or where are the text messages that are referenced on page 12, right? They are able to ask so that if there are glaring holes in the report, this is that function of the hearing panel to say, we don't have all of the information we would need to come to a finding. They also can directly ask the parties. They can ask them questions based on the report. They can bring witnesses in. Again, if they feel that there's something that was missed, this is the opportunity to fix that missing part. It also satisfies the Title IX requirement for cross-exam, that live hearing. But instead of going through every last detail, the report, it is assumed that everyone has read the report, and now the cross is based on, the facts being kind of maybe not in agreement, but the facts being laid out, the two sides being laid out, and then the parties can cross. So the panel is the decision maker in this instance, but they are using a lot of bits of information coming from a wide range of sources to make that decision. So, I personally think that this hybrid model is the best that we can come up with, I think, at the campus level. It gives you that checks and balances, but also allows for a more thorough investigation. Because when you just have a hearing, a lot of information has to come in a very short amount of time. Whereas an investigator can spend weeks, months, pulling together a report and getting all of that information. So rather than just expecting it all to happen in 5 hours, it can actually happen over the course of weeks. And then it feels as though, we've looked under every rock. We've gathered all the information we can gather. So I think, again, we're getting to something that's fair, that's more thorough, and also doesn't, waste everyone's time, in the sense that we get to the hearing and we're going to come up with a decision afterwards. So anybody have questions on those 3 kind of conduct processes? I think, honestly, the hearing panel and this hybrid are the 2 most common that you would see. Every school is going to have different pieces, like, they may have 2 investigators. They may have a panel that has, 7 people on it. Just know that, there's going to be these variations. Someone's asking, what are the qualifications for the investigator and the hearing panel? Great question. Now, there's no kind of legally recognized credentials for any of these positions. I will say, professionally, investigators are generally trained at a number of conferences that provide lengthy, like weeks-long training on becoming an investigator and understanding Title IX and other federal requirements. The hearing panel, often some will be sent to those same conferences. So for instance, like your chair might go to one of these conferences, but the other panel members are relying on the school to train them. And Title IX essentially says you can just train those people once a year. So again, I know I'd had conversations with you all about, in the needs assessment, of how engaged you were with the campus and the relationships you'd created. For those of you who have like a really in-depth relationship, you probably know when they're not training people well. And, you may feel that folks that you've worked with really could use more training. And that might be a place that you as an advocate or your organization might feel comfortable training them in some areas. You may also wish to say, I've attempted to train them. We've asked, you can ask for what credentialing or what training they've received. You may want to pass that information on to the survivor you're working with if you have concerns, or, you may want to say, like, I think I would be uncomfortable with you stepping into that room without an attorney. There's some pieces there that, those relationships that you have with each institution, this is part of that knowledge base, that expertise that you bring in resource gathering and sharing, that frankly survivors on their own aren't going to be able to have access to. So, I think it's a wonderful question. And I think continue to think about ways that with the campuses in your area, that you can, kind of come up with your own evaluation of whether or not you think they're getting trained well. I know as an attorney, we would often share with survivors, we have had a complicated relationship with this school. We would say, while I like this administrator, they are difficult to work with. We would say those things to survivors because it's true. And it's not like I'm saying don't report. I'm saying, let's just be clear about, what we might be walking into. These are some steps we can take to try to be upfront, or lessons learned were to make requests early and often, or something like that. Like we would just say, I'm not in any way suggesting you don't go forward. I'm just saying, I think we want to be upfront about our expectations with this administrator, or, if we're worried about if delay, like some schools really can drag things out, you might want to tell that to a survivor. My experience has been that they tend to drag out the process, which under the new regs, there's no specific time frame that they have to complete an investigation. So, you might want to say, I have some campuses where we're done in a month, but this campus, it could be 6 months before this process is over, right? So again, that could really matter, right? You might have a survivor that's graduating, and that's information they wouldn't have if you weren't able to help them to make those decisions. Again, not to dissuade them from going forward, but just to say it's something to consider. And I mean, not to also mention, if the respondent is graduating and that this school tends to drag its feet, that's another consideration, right? Maybe that your survivor is a freshman, right? But the respondent is graduating. That obviously changes the strategy. Again, things to think through as you're going through each process. Great question. So I wanted to spend just a little time also talking about the fourth bucket, which is about informal processes. Title IX allows for schools to have both an informal and a formal process, and each institution is going to define that differently. There are some similarities in what's offered. I'll be honest, not every institution you're going to work with includes even the ones that I have on here. It's really a new area of kind of campus conduct, and schools are kind of experimenting with what they're going to offer. I will say though, you advocates are in such a good position as you expand your relationships with these institutions to suggest that these other informal options are something they should invest in. Perhaps you have staff who is an expert in certain pieces of this, like restorative, and that you could offer some trainings or some connections that would allow them to expand their informal options. So a couple of things to note here. Sometimes survivors are not interested in a quote unquote consequence or a sanction for behaviors. What they're interested in is an opportunity to educate someone about the impact of what they've said. And there are a couple of different ways that can happen. I think restorative justice is a fantastically good option. But as you and I both know, many institutions don't have trained providers. They don't have third-party relationships with restorative justice providers. And it is not a mediation, right? So I'm anxious that sometimes we want to be clear what we're expecting from restorative, and that they don't just, go find somebody on campus who, did it once and all of a sudden now they're an expert. So this is where like having connections in your local areas to practiced restorative folks is important. I don't know if you all are familiar with Rachel King. She's a provider that I adore, and she does a ton of campus work. So happy to make connections with those of you who might want to bring to a campus near you. So one thing, so with the ways that campuses who do not have restorative options is that they will have a meeting with an administrator and the party that's alleged to have committed this harm. And they will say, this, whatever happened between these, this person who came, you harmed them in this way. Please know that they were offended. They felt, they were discriminated against. And we're going to talk through some ways that this incident, ways you could have said something different, things that we're not going to repeat this again, ever again. So it's just this conversation essentially between a school administrator and the person who's been accused. In some instances, they will actually bring both parties together if the survivor prefers that, where it is an administrator and the two parties to have a discussion about what occurred. Maybe there's an exchange of apologies or better understanding that happens at that meeting. Again, I'm not seeing these ever being allowed in an instance of violence. And they will say that in the policy, it will say certain categories of violence will not be allowed to go through this process. So I think you would be looking at harassment, maybe some lower level, like touching, groping, things like that. And it just depends what would be allowed to go through an informal process. So again, reading that policy is important. Now, you may have a case that involves significant violence where your survivor wants to go through an informal process. And just because the school says that it's not allowed doesn't mean that you couldn't engage in those processes through like an administrator like Rachel or someone else on your staff. You don't have to follow what they're doing, right? If there's a restorative provider, or there's another something maybe population specific or culturally specific option that the survivor wants to pursue, absolutely, you're not in any way kind of prohibited from going with that option. Just know that it would not have the same types of potential consequences because obviously the school would not be involved. But just thinking through, there may be lots of options. You just want to kind of consider each. One very positive piece of an informal process is that it does not include cross-examination, and that a lot of survivors will gravitate towards that because they feel safer going with that than going through a normal kind of full conduct process where they're being questioned and examined. So the one thing I'll say about informal, kind of the big takeaway, is it's got to be in the policy. They should be very specific about what's allowed to go through that informal process. And you may also have better options in your community that a survivor is more interested in. So just maybe always be thinking, is there another option that you may be aware of that may make more sense to the survivor than what the campus is offering? So again, definitely kind of incorporate your expertise, all of your knowledge about your communities, and bring that to bear also in these other options, especially if the school, if it seems, kind of not helpful to do an informal process. So something to kind of consider. All right. Everybody okay on those four different areas for the different types of the process? This next part, we're going to jump into just some of the investigation requirements I'd like you to know. Very simple, but I want you to be aware. If anybody has questions about those processes, just let me know. All right. So we're going to go through these fairly quickly, but I want, just so you kind of know where the boundaries are. So the decision maker cannot be the same person as like the Title IX coordinator and the investigator. This is that piece where we talked about where cross-examination happens. You have to have somebody who is able to hear the cross-examination is able to make an assessment of credibility and use all of the evidence to come to a finding. Generally, the Title IX coordinator's role is to just make sure the process happens, that there is not a biased process. But I think they can't also be in charge of the process and then start making individual decisions about students or employees. So just know the decision maker has to be separate from those two people. So again, a single investigator model isn't going to work, right? Because the decision maker, the person who says, yes, you're responsible, cannot also be the person that did the investigation. So we have to have some kind of hearing panel or that hybrid model to make it work. All right, the school has to be upfront about their standard of evidence. Generally, I'd say in Massachusetts, you're going to have a preponderance of the evidence standard. The second option is clear and convincing. You should never have beyond a reasonable doubt. That is only criminal. If we had to think about the standards of evidence, say on like a numeric continuum, beyond a reasonable doubt would be 99% certainty. Clear and convincing is probably at like 75 to 80% certainty. And preponderance is like 51-49. You just have to tip the scale one little bit to get to more likely than not. I will say most of the Massachusetts schools that I've worked with are definitely using preponderance. You may see clear and convincing when it comes to faculty members, but I will tell you, if you get a faculty case, I would really recommend that you reach out to the Victim Rights Law Center. Those cases are so complicated, and there are a number of other policies. It isn't just the Title IX policy that impacts faculty. There are all kinds of human resources, and they typically have like their own internal, what they call a Senate. They have their own rulemaking bodies. So you can have a hearing about Title IX, but yet they're still going to go through this other faculty Senate process. And I'll be honest with you, I don't know all of the ins and outs of those, but I really recommend that you get some help on any kind of faculty case. In terms of the time frame, all that the regulations say is that you have adequate time to prepare, which we talked about, and that the investigation must be reasonably prompt. So that leaves a lot to the imagination as to what that means. Some schools will say reasonably prompt is 5 months. Other schools will say 4 weeks, right? It just, and honestly, we haven't heard much from the Department of Education saying which end of those two timeframes is correct. Generally, you would be looking at least 10 days to review, say like the report or to review evidence. So that just gives you like at least some idea of what you would be allowed to have in terms of a time frame to review something. Yeah, so just know 10 days is pretty much like an average amount of time that you would be expected to be given some time. So again, have your survivors push back if they're told that they have to read this in 20 minutes and then go talk about it. That is not appropriate. They are supposed to be given a lot more time to review information. So I wanted to talk a little bit more about the determination, which is that finding piece. So the decision maker, right? So likely in our cases, it's going to be some kind of hearing panel decision maker. They have to provide the finding, whether it's responsible or not responsible. They have to do that in writing, and it has to be done at the same time to both parties. So if there's an email, it has to go to both parties at the same time. If it's a letter, they have to be mailed at the exact same time. You can't send an email to the respondent and a letter to the survivor, right? You have to do it in the same way at the same time. Because you can imagine, right? If you give, if it takes 2 days for a letter to get somewhere, but somebody gets it immediately via email, that's going to give the person who got it quicker an advantage. And that's why we say it has to be at the same time. Generally, those are emails. And I can also say that many schools will give a heads up to the parties. They will say, I expect the findings to come in Monday morning. You may want to be with a support giver at that point. They generally never give them out on Friday afternoons because, you know, we want to make sure that especially either party has the ability to reach out and get care if they need it. So, you know, again, that's bad practice. If you see an institution issue a finding like late Friday afternoon, when you can't get on a crisis, you know, can't meet with your counselor or get an appointment, right? So things to be preparing, if you are working with a survivor who's getting a finding back, you know, maybe being together or being able to be on a Zoom when they receive that email and you can read it together, and kind of process it in the moment. So when they receive that finding, it will tell them, you know, it'll spell out the process. It'll say, this is the allegation. These are the investigation and hearing steps we took. They generally will list some facts that they found helpful in making their decision. And those are important to go through, right? What they found credible, what information they found to be most relevant to making their decision. They have to say each allegation. So if there were 3 violations, they want to go through each one and list which ones were found responsible and what sanction. Maybe it's a suspension, maybe it's expulsion, like who knows? There's a lot of things that they can do. And then they have to detail what the appeals process is. Now, the appeals process, I'm not going to go into it too much, but you're going to get these slides and I just wanted you to have them here. So in essence, it's generally these 3. One is procedurally something went wrong, right? That you thought you were going to have 3 witnesses. None of them showed up because they wouldn't allow you to have extra time. And then that impacted your outcome. Had those witnesses shown up or been allowed to show up, that would have really impacted their decision. The second one is new evidence, right? That you just found out some new evidence that really impacts, you know, the outcome, and you could not have gotten that information at the time of the hearing or the time of the investigation. What I want to be clear about is a lot of times folks will say, oh, I didn't, like back in the day, we would get hearings where the respondent will be like, we'd get to the end, that person would be found responsible. And then the respondent would say, oh, by the way, this survivor had sex with 2 more people after me, like meaning in the years later. And they'd be like, okay, so I get to have an appeal. And we would say that is perhaps new evidence, but it will not impact the outcome of this case. And you may or may not have known that information at the time of the hearing, but it has no impact on the decisions for this incident that we are adjudicating. So again, be able to help folks discern, you know, what is really new evidence. Has to be kind of like a bombshell, right? It has to be a picture or surveillance video or a witness that you didn't know about. All of a sudden you find out about this person. It cannot just be, by the way, they got fired from their job. That's not relevant. All right, so somebody says, who else has access to the written decision document outside of the parties? Only the administrators. And that's going to be, so it's a great question. The written email about the findings only goes to the parties. And for instance, if you had a case that had multiple survivors in the case, only those allegations that pertain to that particular survivor will be given to them. So for instance, if they each had a sexual misconduct and a sexual harassment case against the respondent, they would only get the decisions based on their case. They wouldn't get all 4 charges in a letter. They would only get their 2 charges. And then I guess they would have to ask the other party what happened, because I have seen cases where one gets a responsible and the other survivor does not. And so that by FERPA, which is another federal law, they are required to send them separately. The findings letter, obviously the decision maker, right? The panel is going to know. The Title IX coordinator is going to know. Generally, the investigator also is aware. And unless it is appealed, and we haven't even gotten into that, there's another appeal body. Again, if you guys have an appeal, I would really consider going to the VRLC. They're also quite complicated. So things to consider. And they often have a very short time. You generally have like 5 days to file an appeal. So it's like you get the finding letter, you need to jump into an appeal immediately. So, again, you may want to, if you're having a bad experience through the panel, it might be worth it calling the VRLC early saying, this experience is not going well. We might want to appeal and get them involved early. But hopefully that written decision document isn't going to a bunch of other people around campus because it doesn't pertain to them. It is considered an educational record, meaning that you have to have a reason to have it, like a reason to know. So for instance, if part of the sanction was that you couldn't participate in a sport, then that obviously the athletics director is likely going to be told about this sanction. However, if it has nothing to do with sports, there should be no reason why the athletics director would know if it does not impact their program. So again, hopefully, if you are seeing that it's getting passed around, that's definitely potentially another area of violation. But yes, it should only be those few people that are engaged in the process. Great question. All right. Anybody have any questions about the investigation process or those models? Hopefully I'm not completely overwhelming you. It's definitely not my intention. But good, I have a question here. But yeah, it's really something I think that once you kind of get the flow of it, I think that you would probably be more comfortable with it. If you even did one, I think you'd kind of see this is a general flow. So somebody asked, can I speak a little to the K through 12 process? Yes. This is where my true passion lies as well. K through 12 is essentially the single investigator model. They generally do not know a lot of the information that I have just given to you. So you would be providing expertise to them. What I find with K through 12 is they do not even recognize the behavior as a Title IX violation to begin with. I have 2 middle school age kids, and recently there was an instance where a kid completely dropped their pants, was completely nude in class, and was like dancing around. And the teacher just said, put your pants back on. And that was the end of that. And, in my world, that is not something that would, without question, it was, folks were attempting to dance very sexually. It was definitely meant to humiliate another person. In my world, that's a real problem and should be addressed. I'm not saying they should, try to remove a child or anything from school, but what I'm saying is it needs to be addressed for the conduct that it is. And what I'm finding oftentimes with K through 12 is they do not even consider the behavior as in any way gender-based harassment, definitely do not consider it sexual violence, and even less recognize dating and domestic violence within this age range. So I think it's really important, and I know I'm speaking to the choir here about when you see K through 12 is helping folks to know that they are not on their own, that they do have protections. K through 12 is supposed to do almost everything that we've talked about. Where I tend to see all of the focus is on that front end, that first part 1 of the webinar series that we did. I think where you have the most ability to really help is getting some of the supportive measures and the safety planning done. Because what we're finding is, since they don't recognize it as a Title IX problem, there's no investigation. There's no acknowledgement that we've had a problem, but yet you have this terrified survivor. So I think it's really important at that front stage for us to acknowledge it and for us to say, well, there are requirements that they have to give you supportive measures. Even if they're not going to take a complaint, they have to offer you these accommodations or this safety planning that you all can help. And this is where some of your expertise in the community also is going to come into play. For instance, around getting a harassment prevention order. If you see stalking or in a non-intimate partner dating situation, non-intimate partner incident, meaning say two folks at a party who are sexually assaulted. I think these are the types of places where, we may have to look outside of the school, especially in K through 12, to get some of those remedies. So you have so much expertise and so much knowledge of what else is available to that survivor. I hope one day that it's going to be easier for K through 12 folks to get these types of cases. I think we're at least a couple decades away before they get the level of skill that I think campuses have been investing in for at least the last 15 years. Yeah, a lot of K through 12 think that it's just a police problem and that's the end of that. So excellent question. Thank you so much for that. And, who knows, maybe here's looking at you, Hema, maybe someday there's another grant or something we can get to do K through 12 work. It would be my hope. So I just wanted to bring up one, big issue here that I think if we're talking about these types of conduct cases that I want to bring to your absolute attention. So under the Clery Act, there was a provision that allowed both parties to get an advisor of choice that would assist them through the process. So it's important now. So that happened, gosh, I want to say 2013. So fast forward to 2020. And now we have cross-examination. The new regulations say that the person who must do the cross-examination is the advisor of choice. And if a party does not have an advisor of choice, the school has to provide them with one. So obviously there is no restriction on who the advisor of choice can be, right? Other than it can't have an obvious conflict, right? So they can't be general counsel for the school. It can't be the Title IX coordinator, or it can't be one of their witnesses. It needs to, be a person who can kind of objectively help the student, they can be their best friend. They can be their parent, they can be a family friend who is an attorney. It can, technically it can be you all. But I want you to think through that full potential for how it could impact not only the survivor, but you as well. So not only do you have this kind of cross-examination functionality, which I'll be honest with you, as an attorney, I am not even comfortable with that at times. That I can imagine that as an advocate, you may be thinking, what? There's that. So there's just that piece there. So let's kind of go through some questions to think through. So number one is, these are kind of the three things I want you to be thinking about if you were ever asked to be an advisor of choice. And perhaps you want to think about this as an organization-wide discussion around this. So, obviously, if your role is as a support giver, as a navigator, to help people get to resources, to help them think through their processes, I think you're going to want to be clear up front whether or not you have a comfort level with being the advisor of choice and to do that cross-examination role. So it is possible to have multiple advisors of choice or multiple support givers So you may want to say, I don't want to be the advisor of choice, but I do want to be a support giver. Some colleges are now allowing the advisor of choice in the room at the hearing and a support giver, because they're recognizing that you may have a survivor who is disassociating in the middle of the hearing, who is, having a panic attack, who really needs a support giver. And if they've hired an attorney to be the person who does the cross-examination, they lose all the expertise of the support giver. So schools are starting to recognize that, folks may need two support people in the room during a hearing. So be on the lookout for that inside of a policy as well. Know that if you are granted that, the respondent is also going to be granted two support people in the room. And I'll tell you right now, if you walk into a hearing and you see that they have a whole bunch of people, you also should ask immediately, why do they have 5 people and I have 1? I want to call some other people. So just know that, kind of setting up clear boundaries for what your role is going to be with that survivor, I think really can help you to feel comfortable when you say, have hit a wall, like, I don't know anything about that, I'm going to need to get you to someone else, or, so that they don't expect you and then become disappointed if you can't act in that role. Cross-examination is a bit of an art form. And I know many attorneys who are not great at it. I would be one of them. So just know that don't feel bad if that's not your area of expertise. That you can find someone else who can help. Secondly, I want you to think about how your participation in a hearing or in an investigation impacts your privacy protection. So your privilege as an advocate is derived from giving specialized care to a survivor because they are a victim of, say, sexual violence, domestic violence, or stalking, right? If you are giving, information about, like, say you're in a hearing and you're objecting because they, that question you feel is not relevant and it's specific in the policy, right? Let's just say you've become a marvel at the policy and you're like, that you can't ask about how many sexual partners, the survivor had before this incident, right? Which is a blatant violation. But in that moment, you're not necessarily providing the same types of support that your privilege covers, right? Your privilege covers supporting folks who have been, in, the typical needs that you would have a sexual violence or a domestic violence survivor would need from an advocate, not so much reading a policy. And in those instances, when you're in a hearing, there's a potential that you could have litigation. And when, I'll be honest, a lot of respondent attorneys will sue schools. It doesn't happen all the time, but it happens in Massachusetts at some of the bigger schools. And I will say, you may be asked to turn over, records, right? Or to give testimony. And I think where it starts to get difficult is to begin to parse through, well, this was given as a support in my navigator hat, in my advocate hat, and this was given as my advisor of choice hat, right? So sometimes, it's just really difficult to start to figure out. And these are the types of things that a judge is going to have to try to sort through. And I think even more importantly is, I feel like sometimes survivors don't understand that they're putting their privacy at risk. So if nothing else, just to have the conversation about whether or not you should be an advisor of choice up front, if you get asked, and saying, like, this is a potential. Now, they might be going to a very small school, or they might be going, it's just never going to happen. Like, the chances of litigation are very low. And maybe you're like, fine, right? There are a lot of really valid reasons why a survivor would want you in there. They may not be able to get through this process without you. You may be the reason why they ever considered it in the first place. And it is that relationship that you have that is giving them the stability to get through this process. And that's valid and completely legitimate. It's not to say that, that maybe you still feel uncomfortable, but you just do it anyway. It's just that you want to make sure that they have all that information. There's that information is power discussion that we had earlier. I just want any of the decisions that a survivor makes to be made up front, with as much information as you can give them, and that they know that, there may be a breach of those communications when it comes to particular statements made in the course of this hearing. So just be aware of those types of discussions. And, perhaps as a group, have a conversation like before taking one of these cases. Or maybe you just decide that you're uncomfortable with you all being advisors of choice, but yet you are going to fulfill that support giver role. And then just being clear kind of upfront that the survivor might want, and to be honest, if you're going to have cross-examination, they really might want to have an attorney in there, frankly, or somebody who's feels really comfortable in that frame. So just, thinking through what's your role going to be, and what does the survivor think your role is going to be? So I had a question. What if the advisor of choice doesn't speak up for something that's inappropriate to ask? Can the support person speak up, or will that compromise privacy protections? Extremely interesting question. The answer is, I don't know. We have not seen a case come up in that instance. I think just being in the room can sometimes be enough for the program to receive a subpoena. Clearly they're going to know, Lindy Aldrich from, Pathways is here. So they're going to know right immediately that they're going to send a subpoena to Pathways. It may be, maybe nobody's going to respond, right? But they're going to know that somebody has sought services at Pathways. So they're just going to take a shot at that and see what happens. So even if I never said a word, they're still going to know that this survivor has gone to Pathways. If you speak up, I don't know that it necessarily compromises the privacy. I think the reality is, like, if they don't know that you are the support giver, then they can't even send the subpoena. And if you never said anything in the hearing, I think that's a great argument to say, I don't have any testimony to give because we did not speak in the course of the hearing. My role was to be there as an emotional support giver, and that falls within the privilege. So I think they're going to be very fact specific. And I think you're going to want to have these conversations. Like, I've had support givers not be in the hearing, but sit outside, literally like outside the door. And at every break, they go take a walk for 20 minutes, and they're doing breathing exercises. They're doing grounding exercises. They're talking through, the emotions that they're feeling, and they're talking through some of those pieces, so it depends on the relationship that you have. But it's definitely worth, kind of thinking through what information am I giving away by just being here? And what can I try to reel in and protect? Great, wonderful questions. I so appreciate these. I wanted to just to wrap, we're getting close here to the end, is I just wanted to kind of bring up what I brought up before, which I'm hoping you can now see. Even after we got through part one, these were relevant. They're incredibly relevant now. I hope you can see. So number one is understanding the different processes. If you have 5 schools in your area, and I know some of you have like 25 or 50, it's crazy. But if you have, say, a small group of schools in your area, understanding their different, like getting their policies, trying to figure out who has what, right? These are important to think through, so that if you meet with a survivor, you feel comfortable knowing that this is the type of what they might expect. Trying, if you don't have relationships with folks on those campuses, to try to establish some. or to deepen and strengthen the ones that you do have, so that they know and see you as a resource, but also that you can try, especially if you have concerns about their training programs, or you have concerns about maybe not having an advocate on campus, right? There's like, you want to try to, create and deepen those relationships so that they feel comfortable referring folks to you all, so that you can really help survivors, get through and understand the decisions that need to be made, or not, right? Maybe they decide I'm not doing any of this. And then lastly, I think you also round out the options for survivors that frankly some campuses just can't do, like your connections to emergency housing, civil protection orders. Generally campuses don't have the bandwidth to help folks with that, and you're working with local law enforcement in the event that there is a complaint to local law enforcement. That's huge, because again, not all campuses have a great relationship with their local force. Oh, I am already over time. I'm so sorry. I just wanted to tell you that this checklist, everything we've talked about over the past 2 sessions, is available to you, and I might have Hannah jump on, or I don't know if we're emailing it to you all or not. And this is my information. If anybody wants to get in touch with me, or if you have anything that you're interested in pursuing, and look out for more information from us. Hema, I'll throw it back to you. Sorry about that.
Yeah. No problem. I think people have been riveted. I am so grateful. Sorry, my camera is not working, or else I would be on here. I am just so grateful for this information. It was so helpful, and just really appreciate all the context setting on how advocates can continue to do and be the incredible partners they can be with these institutions. And we will be emailing all these materials to anyone who registered here. We'll also make them available to JDI members as a whole on our resource page through Coalition Manager. But feel free to email either myself or Nithya or Lindy to get some information about campus related checklists and other materials. Thank you to our interpreters as well so much. We appreciate you. And our captioner.
Thank you so much for everybody for hanging in there with me. And thank you so much, interpreters. I hope I was able to not talk too fast.
All right. Take care all. Thank you, Lindy, again.
Thanks, Emma.